Hey everybody, it's Sunday, April 17th, 2016. This is Merlin Yvette. It's been said that a picture is worth 1,000 words, and so what I'm actually going to be doing is just sharing the picture of all the various different pieces of the puzzle and chronological events and how we got to this point. Really quickly, I'm trying to make these videos brief, so I'm going to blow through it really quickly and then I'll explain a little bit of what we're looking at. This is really kind of the trajectory of where things started approximately in September of 2015. And so I'm just going to go over those events and it's going to bring us to where we are today. Okay, so September 2nd of 2015, I was forced to file an enforcement by contempt for father's violations of final order. We're going to go over and explain all this later, but right now we're going to move forward to this. 9-2 was the immediate filing of subpoenas for the continued October 2nd, 2015 protective order hearing from the Domestic Violence Agency and expert witness. This is actually referring to Genesis Women's Shelter in Dallas. So I filed those. Now, the order of these actually that was a little bit backed up. The first thing that happened on this date was actually September 2nd, my protective order hearing, and this was actually in Judge Chris Oldner's court there in Collin County, Texas, in the 416th District Court. I actually had this first. I showed up with a domestic violence advocate that was actually from, let me think that day, what agency I had with me. That particular day, actually, it was from Genesis Women's Shelter. So the domestic violence advocate was there with me. We were on time for the protective order hearing. Previously, I had reached out to Kenneth S. Harder of Carrollton, Texas, which is Curry Obafemi Johnson, my daughter's father's attorney. Previously, I had reached out to him with regards to the enforcement issues and doing what they call a certificate of conference attempt. That means before you file things in Collin County under local rules 3.0, 3.1, and 3.2, it states that you're supposed to contact the opposing party or if they have an attorney opposing counsel before you just haul off and file motions. 3.3, I'm doing this from memory, so if I'm incorrect, I'll correct myself later. Please forgive me. But 3.3 says, nor shall a clerk set any hearings if a certificate of conference is not included in the motions. And so I had actually contacted Kenneth Harder to see if he was representing Curry Johnson in any capacity. That was with regards to our SAPSER suit. SAPSER means suit affecting parent-child relationship with regards to our daughter, or with regards to any protective orders or criminal defense. Mr. Harder is a criminal defense attorney, as well as family law, as well as he does a lot of financial white-collar crime stuff. So ultimately, I contacted him to give him opportunity to conference and resolve the matters before filing these issues, and he specifically put in writing, I am no longer involved. Well, on the date of the September 2nd, 2015 hearing, Mr. Kenneth Harder, who's no longer involved, and of course, Curry Johnson, I had been also doing certificate of conference attempts with him at that point, assuming he was pro se, because he would not give me attorney information, asking him, okay, we had been talking about going back to court, so I said, okay, please put me in contact with your counsel. And so he had made threats about going back to court. When I say a threat, he has the ability to make a threat to sue me legally. Now, a lot of people start to talk about legal abuse syndrome, and is it a way to further exercise power and control over victims once they've left? Yes, it is. However, it's not a crime. It's not something you go file a protective order on. It's not something you go make allegations about abuse on. He can threaten to take me back to court as much as he wants to, and he had been doing that. We'll go over those emails later. But I was also saying, no problem. If you can't provide our daughter's medical information and comply with the court order, I have no problem going back to court. And so ultimately, I did everything I was supposed to do per local rules, which actually are approved by the Supreme Court. Collin County local rules that are current right now were approved March 10th, 2015, I believe, by the Supreme Court. So they're amended rules. They, if changed, have to be publicly notified of the change. So it's supposed to be readily available. Collin County posts theirs on their website. But anyways, I had done all the prerequisites. He had not given me attorney information. Ken Harder specifically responded via email, I'm no longer involved. So now me and my domestic violence advocate witness from Genesis Women's Shelter, where my family and I had been a client first through their shelter. So being there as a shelter client, just about the 6 weeks, we left about 4 days prior to the completion of our 6 weeks. But we were there with the listed abuser being Curry Obafemi Johnson for his fatal shooting and murder threats of me surrounding my fight for supervised visitation and child support with regards to our daughter. Under the Texas Family Code, we'll go over that later. Threats, very serious threats such as that. They're terroristic threats. They're also considered family violence. And so that's why I qualified to even be a client of Genesis Women's Shelter, as well as the Family Place, as well as Hope's Door. Hope's Door actually was a client based on another case, and we'll talk about that later. But ultimately, you don't just get into these agencies and organizations and them support you unless what you have gone through, and there is a vigorous screening process, and then they continuously screen you while you're there. You don't get to be in domestic violence shelters or family violence shelters unless there is domestic and family violence. They're very familiar what that's defined as. And so you don't get to just hang out there because you make an allegation, say, oh, I'm being abused, I need a place for me and my kids to go. Okay, I want to hurry up and get through this because Mariah just woke up and she's not going to let me get through all of it if I don't hurry. But ultimately what happened on September 2nd, 2015 in Judge Chris Oldner's court is we walked in, we were on time. We were sitting, we were waiting. It gets to 9 o'clock, which is the appointed time for the hearing to start, and they don't show up. We wait a little bit longer. Of course, Chris Oldner continues with other other cases that were scheduled that morning. And finally, around 9:30, I went to his bailiff at the time. So whoever his bailiff was on September 2nd of 2015, that would be the bailiff I'm talking about. And I went to him and I said, okay, I'm here for my protective order. The opposing party, which was Khary Obafemi Johnson, he has not showed up. He has no counsel that has showed up. I'd like to approach the bench and get a default judgment for my protective order because he's no-showed. The bailiff tells me, no, can't do that, sit back down. So they denied my right to request a default. This is going to be pretty interesting as we get to where, quite excitingly, the courts entered defaults against me, but this is one of the 3 times that Collin County judges denied defaults for me. The other time was pretty critical on 7/24/2014, which was supposed to be our hearing to establish paternity, where the DNA results were coming back, and we were supposed to put all the matters pertaining to our daughter, which was conservatorship, visitation and access, child support, medical support, and of course, again, DNA confirmation. Khary Obafemi Johnson was notified in June when we were ordered to take our testing that day. He was ordered to reappear again on July 24th, 2015. Of course, he didn't show up because a protective order had been issued the day before. Apparently the day before after that, he also retained Kenneth Harder. But ultimately, when that hearing in the IVD court with Judge Martinez took place, this is another time that I was made to sit literally over 6 hours to sit in the jury box area because they were aware of the family violence situation and the threats. Protective order had just been issued the day before. I was made to sit up there literally for 6 hours. Okay, so I listened to every case that was heard that day. I had a witness with me on that day as well. That gave me a gift a little bit later with regards to all those proceedings, so I'm thankful for that. But ultimately, at the end of the day, they made me sit there for literally an entire day before they were even willing to call my case. IVD managing attorney Tristan Harper sat there with me for about an hour and put together, again, what we were proposing, what we were going to argue that day we wanted as far as an order in the best interest of our daughter. After 6 hours, again, of me having to sit and wait for Khary Obafemi Johnson, who was noticed in June to be there, Tristan Harper of the OAG did ask for a default judgment. When people are properly noticed to be in court and they don't show up, typically if they needed service, physical service, and the return of service has been on file, they can enter a default judgment in accordance with the law. If they are personally noticed by the judge in court, and that was also placed in our 7/24/15 paperwork that says, though duly noticed, he did not show, then the opposing side has the right to ask for a default judgment, and it should be granted, should be issued. But of course, since Marlene Yvette is blacklisted from justice in Collin County, I did not get that default judgment. So that was another time I was denied a default. Another time was in Judge John Roach Jr.'s court. So this is the 296 of Collin County. This would have been on August 11th, 2014, after the 7/23/2014 temporary ex parte protective order was issued against Khary Obafemi Johnson, and he was served, and that return of service was provided back by Denton County constables who delivered that to him at his job there at Peterbilt in Denton. So all the prerequisites of proper service, proper notification were met. Again, Kenneth S. Harder, who's been practicing law as long as I've been alive, really since the 1970s. I was born in 79. I believe he started practicing on or around there. So this guy's been practicing over 35 years. He's had numerous cases in Collin County. So again, he's very familiar with his responsibilities as an attorney to show up for hearings. He's also aware that if for some reason he cannot show up for a hearing, the proper legal remedy for that is to file a motion for continuance. Of course, he also knows he's got to contact opposing counsel first. He's got to work that out. But there's a proper legal process. Besides, I have a conflict, I'm not showing up. So instead of him actually following the proper legal process as a 35-plus year attorney who knows better, he simply wrote a letter to Judge John Roach and told him, hey, my schedule's kind of full. I got other things going on, so I'm not going to be able to make it. Judge Roach did not reset the hearing. He did not give him permission to not attend. And so ultimately, Ken Harder prioritized his schedule the way he wanted to, and he decided to, again, just not show up for the hearing. So, again, in him not showing up for the hearing, ultimately, we should have been able to continue with the hearing that day with Khary Obafemi Johnson representing himself because his attorney failed to show up. And then, of course, he would have had a malpractice situation with his attorney and being negligent and not showing up to represent his interests. But instead, what did they do a third time? They denied my default judgment. They reset the hearing, and I was actually, I was willing to reset the hearing because I didn't know at that time that them choosing not to show up for a hearing meant that I could have gotten a default. And of course, that wasn't offered to me. But I was amicable. I wanted him to have an opportunity to defend what I was alleging because, again, there's no allegation I will ever make against anyone or ever have made against anyone that I'm not fully prepared for them to respond and give their side to and to be able to hash out because I don't make false allegations. I actually loathe, hate, have a deep disdain for people that make false allegations because when they do that, they make it more difficult for those that have legitimate allegations and need legitimate help and protection. We all get thrown into the same basket of someone just making allegations, false allegations of family violence to gain ground in custody suits. Mothers do it, fathers do it. It's sickening and you need to stop. You all are part of the problem and the reason why our family court and child protective service systems are in the state that they're in America today. And the biggest sufferers are the children. So if you're watching this today and you know that you've had a history, you're contemplating, you have done or you're doing, and engaging in the acts of making false allegations against the other parent to win ground, I just need you to understand that there's other powers that are seeing, that are hearing, that are listening. Everything eventually will come back to haunt you and your children and blow up in your face. And you're just making it a worse overall situation for everyone. So please stop. But ultimately, going back to that hearing that day, that was the third time that, again, Marlena Yvette showed up for hearings on time. Again, Kenneth S. Harder, 35-year attorney, neglected to show up on time or at all. Okay. And I was denied my defaults. Now, this is going to be really interesting as I blaze through the next issues here. So ultimately, on 3 different occasions, 3 different judges in Collin County, Marlena Yvette shows up on time, waits a while, requests a default judgment, and I am denied. This will be very relevant when we get to 10-2 here in just a moment. But that's what had happened on that day. Kenneth Harder says, again, represents in writing. We'll go over that email later, and actually there's proof of it that will hit with everything else, or when I say hit, meaning come out with everything else. He says I'm no longer involved. But here, me and my witness have been sitting. My domestic violence advocate have been sitting. We've been waiting. We've requested of Chris Oldner's bailiff to allow us to come before the court and present my default orders that I had already prepared. My proposed orders to be signed on default. Of course, Judge Oldner, he denies that opportunity. And we wait until Khary Obafemi Johnson strolls in at, I believe, 9:40. So he's 40 minutes late. And then we still can't go before the judge. We wait until 10:03, which is the time that Kenneth Harder strolls in. So again, I'm a mom. I know I'm not anyone important. I know I have nothing better to do with my time. Kenneth Harder actually states and educates me on this in the murder conspiracy audio that is being released. That, you know, I don't have anything better to do with my time, but he does. He's so important. Khary Obafemi Johnson is so important. I know I have no value. I'm just the child's mother and the reason that she even made it here alive, and sustained, of course, all this time. But anyways, he says, of course, I have nothing better to do. But when he walks in promptly, as if this has already been arranged, or he notices now the parties I actually want to hear from have shown up, talking about Judge Chris Oldner, now he calls us up. after an hour and 3 minutes sitting and waiting for Judge Oldner. So when this happens, obviously naturally, as I have asked for weeks, Kari Obathemi Johnson, Kenneth S. Harder, let's talk about the issues. One, the violations of the allegedly signed May 14, 2015 final order. I say that because we had a hearing on 5/4/2015. And then, of course, Collin County unlawfully sealing my case, not allowing me the opportunity to know when it was signed. So I'd have my 3-day right to de novo hearing, which you have when an associate judge makes a ruling. Of course, all of that had been stolen from me collusively at the hands of multiple people there in Collin County, including the Collin County District Clerk's Office. We're going to talk a lot about that because if the agency that all filings have to go through, court records are supposed to be maintained, is corrupt, and they're filing only what they want to file, they are creating whatever record they've been instructed to create or decided to create for whatever the reason, you literally have affected the integrity of fact and law and truth for all of the cases that are running through the Collin County Courthouse. So this is pretty major, but ultimately, collusively, my right to de novo had been denied, and so it had created some serious collateral estoppel issues or going behind the previous order issues. What this means, and I'm not giving legal advice, I'm just explaining in my situation what happened as it pertains to this protective order hearing. Collateral estoppel or going behind the previous order means that in my case, Kari Obathemi Johnson had made many threats regarding if I proceed with child support, retroactive child support, which means from the date of our daughter's birth to the date they order it, or if I continued to fight for supervised visitation access done at an agency or another way for our daughter, which he wanted unsupervised, complete control to do whatever he wants, which if not for his drug dealing lifestyle, his criminal background, and his constant DWI drunk driving, I would have been fine with. But unfortunately, due to those issues, I couldn't be fine with it because I don't want our daughter in harm's way. And again, I tried to work with them for a year on what are some other alternatives so I know that she stays safe and she's not in your car where you meet people to deal drugs. She's not with you in other arenas where, you carry a gun full time because you know at any point in time you might need it for your protection. I don't want her caught in the crossfire of that. So this is what the issues have been about. But ultimately, as I was going through my pregnancy and when he made his first threat to me, I believe it was August 27th of 2013, we were sitting at Central Market in Plano in his car, so gun present. He just says to me, I hope you don't plan on trying to keep her, our daughter Mariah, from me, Kari, Marlena, because this is how people end up shot in the penitentiary and kids come up missing and not being returned. Now, a lot of people say, well, he didn't say he'd kill you. But we all understand if someone walked into any courtroom in America and said to a judge, Judge so-and-so, I hope you don't plan on ruling against me because this is how judges end up shot in the penitentiary and their family members come up missing. Immediately, we all know that that judge would order that person confined and they'd probably never get out. Why? Because the implication is pretty darn clear that that was a threat, which of course at that time I said, did you just threaten me? And of course he says, no, I'm just saying, you see it in the news all the time. And the reality is, everyone, he's right. So these would be the warning signs. These would be some of the audios that I had and proof or evidence through emails and others that I had of his threats against me. And so I wanted to be able to present those. Unfortunately, because those were when I was allowing visitation without being court ordered to, because they were prior to the 7/24/15 order being issued, they are now barred by collateral estoppel or going behind the previous order. That means if they were not allowed in to be discussed on 7/24/15, right, then they can't be brought up past the date of the court order, which creates a serious obstruction of justice to my case and the facts actually being heard and the facts of family violence actually being founded. Findings of family violence affect the trajectory of how temporary orders or final orders in family law, Texas Family Code matters and how they go. It kind of ties the judge's hands a little bit because then they actually are forced to protect the victims, being the person that's receiving the family violence actions or threats, as well as the child. And so this is one of the reasons why ultimately, they didn't want to proceed with that. So now I'm going to go ahead and have to stop recording because baby girl's up and definitely wanting some attention, but I'm going to get back to this and I'll just run over briefly. Well, I'm going to stop right now and I'll come back to it so I can tend to her. Thanks.